Video 2 of 3, Physical Restraints, Legislation and Policy on the Use of Physical Restraint.
So this is a video series delivered by Archsby Law Center in collaboration with the Disability Law Intensive and the Disability Justice Network of Ontario. My name is Gabriel Resnick and I am a staff lawyer at Arch.
And my name is Victoria Kassar, and I am a disability law intensive student at Arch and a law student at Osgoode Hall Law School.
Overview of video.
So what will be the focus of this video?
The focus of this video, and this is the second video in a three-part series on the use of physical restraints, and the focus of this video, we will discuss the laws and policies that govern the use of physical restraints in schools.
Legislation on the use of physical restraints.
So what does the law say about the use of physical restraints in schools?
So while other provinces have a province-wide policies on the use of physical restraints in schools, Ontario currently has no legislation, regulation, or policies that specifically govern the use of physical restraints on students. There was a Bill 160 that was before the Parliament, was brought by Michael Coteau as a legislation. This bill was directly about the use of physical restraints in school, and it would implement similar standards as other provinces. Unfortunately, the progress of this bill stalled in 2019, likely as a result of the COVID-19 pandemic, and since then we've had no legislation on this issue.
So what about the Ministry of Education? Do they have any regulations or policies on the use of restraints in schools?
Unfortunately not. The ministry has not established a policy on the use of restraints.
So what is the issue with having no legislation or regulation or policies on the use of restraints?
Well, the lack of guidance means that there are no provincial-wide standards that govern and guide school boards on when, where, and how physical restraints can be used. Instead, each school board is left to develop their own restraints policy, which is concerning because this is something that is significantly restricting an individual. It's about someone's dignity, and the law has not spoken at all about this issue. This lack of legal guidance is problematic further because the Ministry of Education has not collected information on the use of physical restraints, and there isn't any clear guidance on whether even parents need to be notified about whether physical restraints occur. And so it's very troubling that we don't have these legislation, regulations, or policies because we don't even know how often they're being used. And these are, like I said, this is something that is significantly impacting an individual with a disability.
So are there any parts of the law that we can look to regarding this issue? How are school staff allowed to engage in the use of physical restraint on a student?
So there are some laws that do provide minor oversight on the use of restraints in schools, specifically the Criminal Code, which is a federal law. So education is provincial, but there is the Criminal Code, which is a federal law that does speak to the use of physical restraints. It outlines that school teachers can use physical restraints with reasonable force under reasonable circumstances, such as a threat to injury to the individual, so the student, or to another individual. Essentially, what we have is an exemption in the law that allows teachers to use physical restraints in an education setting. However, the Criminal Code requires the person using force to avoid pain, to avoid any degrading or cruel treatment, or punish the student. In addition, it outlines that this can't be the first thing that is being used, that it should not be used under a normal situation. Section 43 was once challenged. So this is under the Criminal Code is Section 43 specifically, and this was once challenged at the Supreme Court of Canada because it was argued that it violated students' rights as guaranteed by the Charter of Rights and Freedoms. However, the court found that Section 43 was constitutional, which means that it still exists to this day. There's also a Regulation 70 under the Child and Family Services Act. This regulation is not directly applicable to the education setting. However, it can be a standard that is measured against. So in future creations of regulations, there can potentially look at this regulation as an example of a regulation for physical restraints. This regulation sets the responsibilities and requirements for using physical restraints in youth residence, requiring that restraints are not to be used as punishment, but only to prevent imminent injury to the child. Persons applying restraints must be trained to use the least amount of force required and monitor the child's condition throughout. When there is no longer an imminent risk of injury, the restraint must stop. And persons who apply the restraint must document it. So there must be documented proof that the restraints occurred, why it occurred, and that must be reported.
What is the role of school boards in the use of physical restraint?
So how are school boards involved in the use of restraints?
So given the lack of governmental guidance, each of Ontario's 84 school boards are left to implement their own policies and procedures on the use of restraints in schools. Due to the lack of provincial guidance, there can be many inconsistencies in the standards and procedures on physical restraints within school settings, as they may have different policies. Different boards may have different policies, and therefore you'll see some inconsistencies across the law when it comes to the use of physical restraints. For example, school boards may differ in their process for documenting and notifying the use of physical restraints. However, in a review of the available school board policies on restraints, which there weren't that many, so it's important to note that we did review and we couldn't find that many school boards that had a policy. So if you are afraid that physical restraints are happening at the school, it's important that you request a copy of the policy. And what we've seen, though, in the policies that exist is that they should only be used when there's imminent threat of danger, and that they're very similar to what is currently stated in the criminal code. Also, it can only be used as a last resort option available. Other strategies must be used first to calm the student and to assist in dysregulation.
What can I do if I'm a student or the parent of a student who has experienced physical restraint?
So what is your advice to parents and guardians and students on the risk of the use of physical restraint?
So the first thing is to consult your school. Okay, so just had to outline to understand what the policy is, because without understanding what the policy is, it's difficult to start the process of potentially challenging the use of physical restraints. However, if no policy exists, ask the school what the normal process is in respect to the use of physical restraints in the school. It's important to determine whether the student's school is required to document and report incidents of physical restraints, and if they're not required, speak with the school administration to request that you are notified if this occurs. And you should do all of this in writing to ensure that you have documented proof that you are requesting this information.
Contacting Arch Disability Law Center for legal advice.
And so if an individual wanted to contact Arch, how could they do so?
They can contact Arch by telephone at 416-482-8255, or they can call our toll-free number at 1-866-482-2724. We also have a TTY number, which is 416-482-1254, and a TTY toll-free number at 1-866-482-2728. They can also send an email to intake@arch.clcj if you're unable to contact us by phone. Arch can provide summary legal advice about the situation upon your contact. Thank you.